Good
Please
afternoon.
introduce yourself. Please introduce yourself.
Yes, sir. So my name is Jijnasa Panda. My roll number for the OPSC OJS examination is 500125. I have been a student of BA LLB from Institute of Law, Nirma University, and a student of LLM from Gujarat National Law University with Constitutional Law as my specialization.
Okay, thank you. What is this basic structure doctrine
So
of the Constitution?
Yes. So basic structure doctrine is has been developed through precedents by our judiciary through different case laws. When essentially when in our pre-independence era, where zamindari system was very prevalent in our India, then there were a lot of property concentration of wealth in particular places. So for that, after our independence, our government actually for welfare of the state actually took some of the properties to reduce the concentration, which led to violation of right of property, which was at the time was a fundamental right. So a lot of cases came to the courts challenging those policies, and at the time the basic structure doctrine was evolved in the case of Keshananda Bharati versus State of Kerala, where essentially the question arose was whether legislature had the power to amend fundamental rights or not, and does the court have the judicial power of judicial review for the same. The Having a very balanced approach in the case of Keshananda Bharati versus State of Kerala, the Supreme Court held that the legislature has all the powers to amend, and all the procedure can be followed to amend the entire constitution. However, the basic structure, that is the pillars of the constitution, cannot be amended, and gave a list of things that fall under this basic structure doctrine.
What is doctrine of pleasure?
So, doctrine of pleasure is under Article 310, where certain posts are held by certain officials under the pleasure of the president or the government.
Whether getting this electricity, getting electricity from the electricity company
Yes.
is a fundamental right of a citizen.
uh, so I am not sure about this, but I think it is a fundamental right. It should be.
What are your optional subjects in OJS examination?
So I had law of crimes and law of torts, constitution, jurisprudence, and law of property.
What is negligence?
So,
In short,
under tort, negligence is when certain there was a right of the plaintiff, and that right has been violated. There was a duty of the defendant, and that duty has been violated. That would be tort of negligence.
what is the leading case in the matter?
Uh, sir, leading case would be Donoghue versus Stevenson,
What is that case? Popularly known as?
ginger bottle bear case.
Tell me tell me an act which is both a tort and a crime.
Uh, so these kind of actions are also popularly known as felonious tort, because of the nature of the action, which is under both crime and tort. The major actions would be act of defamation, conspiracy. However, conspiracy, there is an act of overt act required under civil conspiracy, which is absent under criminal conspiracy. There is wrongful restraint, and nuisance could also qualify. Yes.
What is the difference between liquidated damages and unliquidated damages?
Sir, unliquidated damages are the ones which are not pre-calculated, as opposed to liquidated damages, which is generally under contracts, which are pre-calculated on the occasion of breach. If the party breaches certain conditions, then the penalty is pre-decided.
Why penalty? If in a tort, a penalty is given.
Sorry, sir. Compensation is, sorry, sir.
What is
Compensation.
penalty? When a penalty is imposed,
So penalty is essentially a part of criminal law and not in civil law.
what is a declaratory suit?
So a declaratory suit would be where the legal rights of the plaintiff is under a threat. That there is a chance that the legal right could, or the right to property could be actually challenged in future. So the plaintiff goes to the court to declare certain rights that he has, and a declaratory suit is essentially should be a comprehensive suit. That is, all the further relief should be asked in the very suit.
In every suit, declaratory suit, further relief is required.
No, sir. Not in all, but if there is a further relief present, then it has to be asked in the same suit.
What do you mean by injunction?
So injunction is a preventive relief. Whenever there is a chance of irreparable loss to the plaintiff, and there is he can go approach the court regarding the same, and there are certain kinds of injunctions present. Whenever there is a threat to the right of the plaintiff, he can approach the court to
What do you mean by irreparable loss?
so irreparable loss would be one where even with time and money and all the resources, it cannot be reversed back to status quo ante.
A, a farmer is in possession of a piece of land of
Yes,
only 20 decibel.
yes,
He was about to be dispossessed
yes.
by the other side. He asked for a temporary injunction. I'm not an injunction, you temporary injunction. Whether it will be granted?
So it might be granted because his living his employment source of living is coming out, if that is coming out of the land, and if he is going to suffer a loss that is so crucial, that is going to hamper his life, and also maintaining the stance that the defendant also should not be severely negatively impacted from that injunction, then such injunction can be provided.
What is doctrine of double jeopardy
So
in criminal proceedings?
doctrine of double jeopardy is under both the constitution as well as under code of criminal procedure. Under CRPC, it is provided under section 300, where where the conviction as well as any prosecution on the same offense cannot be done twice. That is to protect the person who has been prosecuted once, he should not be prosecuted again for the same offense. This is there to protect the person from time and again is staying in anxiety that once his case has been decided, it should not be brought up again and again by the victim.
What is arrest?
So arrest is keeping a person in custody through legal process.
Police told a person that I am arresting you,
Yes.
and that person submitted the body of that person to the police. Yes, I will go with you. Whether the
Yes.
police can touch the body of that person?
So under section 46, touching the body of a person while making an arrest is permissible. However, if the person is himself accepting that he is ready to come with the police and he is not resisting the process, then there is no need of touching the accused, essentially.
Can the police handcuff a person accused?
Sir, handcuffing is permissible. However, under section 49, there is a restraint of unnecessarily restraining a person, and also under the landmark case of Arnesh Kumar versus State of Bihar, the Supreme Court held that unnecessarily putting the accused in handcuffs is not required if he is not resisting the process, or there is no threat of him fleeing away, or the gravity of the case is not as such that requires the handcuffing, then it is not required.
Can a woman be arrested by touching her body?
Sir, under the proviso of Section 46, touching of women while making the arrest is not permissible. It should not be done unless she acts going out of her way. She actually does some action which requires the touching, and that too by the women police officer only, and not by a male police officer.
Is police is permitted to cause death of a person while arresting that person?
So they're not permitted as such, but if they do cause the death of a person, then it should be in a case where it is punishable with death or life imprisonment. It should be a very grave offense, and his absconding could have cost a lot. If the stakes are very high, in those situations there could be a death, but then also the public servant would be exceeding the powers of his public duty, and it might also fall under section 300 in one of the exceptions.
In a particular section of the Criminal Procedure Code, simply there is a magistrate can do a particular act.
Yes.
Then without qualifying any word, a particular magistrate, then which magistrate will do it?
Sir, I'm sorry, I did not understand the question very well.
Suppose magistrate,
Yes.
without qualifying word magistrate,
Yes.
whether he will be judicial magistrate or executive magistrate. Is there any provision to that effect?
Sir, magistrate is understood as judicial magistrate.
What is confession?
So there is no definition of confession given under the Evidence Act. However, the definition of admission is treated as a definition of confession as well, but towards the guilt of the crime. So an admission is essentially a statement, whether oral or written, towards admitting certain facts, which creates inference towards the fact and issue or relevant fact. This statement, when it goes towards the guilt of the guilt, admitting of the guilt of the crime, then that is called a confession under section 24. It comprises.
What is admission?
So admission is any statement under section 17. It is described as any statement, oral or written, which gives inference towards a fact and issue or relevant fact in a case.
What is the evidentiary value of admission?
So it is a weak kind of evidence. However, because there can be reliability placed on admission, because no one actually goes against his own interest. So self-harming admissions are actually admitted. However, they are usually used as estoppel and not a substantive piece of evidence.
Can there be an admission against law?
No, sir. Admission against law is not.
What is estoppel?
So estoppel is when a party or his representatives are not where a party or his representatives are not permitted to go back on the statements that they have made during the trial. So if, for example, if a person states that he has a particular document in his possession, later on he cannot give evidence towards the fact that he did not have the document all
If
this
the
while.
principle of estoppel is applicable in criminal case,
No, sir. Estoppel is applied in civil cases only.
so you told that trial is always in a criminal case.
I'm sorry, sir. In a case, in a case.
What is the difference between inquiry, trial, and investigation?
So, investigation is a collection of evidences by a police officer or any person who has been authorized to do the investigation. Inquiry is only done by a magistrate or a court. But inquiry, the definition that has been given of inquiry is essentially a negative definition which makes trial and inquiry mutually exclusive. That is, both of them would not overlap during the procedure. Trial, the definition of trial has not been provided under CRPC, but trial is something where the evidences are appraised and the judgment of the particular case is given.
Can a private person make investigation in a case?
If he is authorized by the magistrate, yes, sir, he can.
What are the requirements for a valid adoption?
So, I'm sorry, valid adoption.
adoption under the Hindu law.
Yes, sir. So, for valid adoption, the person who's adopting, if he or she has a spouse, then the consent of the spouse is essential first, provided that the spouse is not has not renounced the world or is not of unsound mind. Secondly, he should be major and of sound mind, and if it's a male, then there should be an age gap of 21 years if he is adopting a female child. It's given under section 7 and 8 of the act.
Whether registration of a document is required for adoption.
So I'm not sure about this, but as far as my knowledge goes, it is required.
If contract was your subject in the,
No, sir.
then what are the optional subjects?
Sir, law of crimes and torts, constitution and jurisprudence, and law of property.
What is lease?
Sir, so lease is an agreement between a lessor and a lessee, where the property is given for a temporary period of time on a provided
Then what
rent.
is license?
The license is provided for a particular purpose as opposed to lease. License is provided for use of a particular purpose of the property.
What is actionable claim?
So actionable claim includes I'm sorry, so just 1 minute. So actionable claim is any claim on a movable property over the possession, or else some unsecured debt, like which does not include mortgage or hypothecation. It should be unsecured.
Then what is mortgage?
So mortgage is when, sir, a mortgager, the agreement between a mortgager and a mortgagee, where a property is transferred to the mortgagee in lieu of a certain debt or payment of service.
Okay. Who is an ostensible owner?
So ostensible owner is provided under section 42 of the act, where the owner that is named on the deed is not the real owner. The real owner is the one who has paid the money for the property. This ostensible owner concept has, however, been now abolished through Benami Transaction Act.
X is the possession of a piece of government land.
Yes.
The government dispossessed him.
Yes.
Can he bring a suit basing on possession only?
So not against the government, no, sir.
Which section of the which
So
law prohibits it?
Sir, Section 6 of the Act.
Whether you're in which place, whether you have a urban background or a city background or a village background.
Sir, I live in Sambalpur, so it cannot be called urban or it cannot be called rural also.
Your permanent residence in Sambalpur.
Sir, I'm residing in Sambalpur. My
You are
background,
from which place? You
sir,
are which place?
actually, my father's relatives are from Puri, and they have lived in Rourkela all their life. My father's side, but we have been here in Sambalpur for almost around 20 more years.
Okay. What is your idea about this? If, that is abolition and making a provision in the Water Act. That is a regulation that tribal can transfer his land.
So,
There is a total. Now it is agitation is going on. There was a previously the tribal was not allowed to alienate his land to any other person if he is not tribal.
yes.
Now the government has made rule. in the meantime, that is a all cabinet decision that a tribal can alienate his land with permission of the revenue officer to a non-tribe. What is your idea? Why such a revolution is there? What is your thought?
So, in as far as my knowledge goes, the original provision was present for the protection of the SCST rights, because at the time in previous times, where since the tribal people did not have certain idea about the market, the market and the value of their land in the market, and they used to be deceived by certain parties to sell their property in lower value than the market value. So this provision was present for the protection of the tribal people, and it was a very effective, and in my opinions are very much required and very beneficial for them. However, the provision also caused a little bit of pragmatic problem when it comes to selling their land, because the pool of people to whom they could sell the land became very small, and thus the market value automatically decreased in certain situations. So in either case, the actual benefit of the provision could not be reached to its maximum level. So this qualification of this protection has come recently, where the tribal people can sell their land. So this protection, in my opinion, I feel would be a very effective protection if it is actually actually applied uh, in a very regular and very effective manner.
Take for an example,
Yes, sir.
X is a tribal person.
Yes.
He was working there in Delhi in a big company, earning lakhs of rupees. He has a piece of valuable land adjacent to Sambalpur. That is also worth of crores of rupees. He wants to transfer that land. No tribal person is available. No this money or rich tribal person is found in Sambalpur area to purchase that land. But another person who is not tribal, he is available. He is willing to take. If such denial permission is denied, whether there will be injustice to that person. He's a, but because he is a tribal person.
Yes.
In such
Mm.
case, what will your idea?
Sir, so this would differ from fact to fact, since in this particular situation the facts are very different than our idea of how a typical situation would go. Sir, in this case it seems like it is a it I mean, it is not uh, ideal that he cannot sell his land, as he doesn't have the freedom to sell his land as all the other people have. However, the protection of the protection of the provision that is given to tribal people is also very important in my opinion. So doing away with the protection would cause more harm than benefit, in my opinion, I think.
What is your father doing now? What is in which
Sir, he
profession
is
your father?
retired. He was a teacher. He is retired now.
He was a teacher.
Yes.
You are permanently settled in Sambalpur.
Yes, sir. We are here in Sambalpur.
Okay. Thank you. After this interview by second panelist, I will give you my feedback.
Thank you so much, sir. Thank you. I'm so sorry, sir. I thought the interview was over.
Yeah, sir. Please tell me what's a clog on redemption?
Uh, Sir, a clause on redemption is a clause present in any of the mortgage deed where the right of the mortgager, that is of redemption, is taken away, either directly or indirectly.
Okay. Okay. What is the period of limitation in a case where there is no period of limitations prescribed?
So it is 3 years.
What is the lowest period of limitation given under Limitation Act?
Sir, I am not sure. It might be 1 year. I'm not sure, sir.
Okay. Tell me whether an anticipatory bail can be granted if no FIR is lodged.
Sir, lodging of FIR is not a precondition for anticipatory bail. However, the facts of the case cannot be vague. It has to be concrete facts on which anticipatory bail is accepted or provided.
What is an anti-suit injunction?
I'm sorry, sir, I'm not aware of anti.
Can you tell me the difference between prohibitio writ and certiorari or certiorari?
Yes, sir. So both of the writs are provided under Article 32, where and both are imposed on the courts. Certiorari is imposed where the judgment has been provided, and such judgment is to be stopped from being applied or imposed. And in prohibition, where the court is about to give a judgment during the case pending of the case, the writ of prohibition is applied, and the court is stopped from giving a judgment.
Okay, okay. What is the doctrine of merger of decree? Merger of decree?
Sir, I'm not sure about the concept. It might be about uh, where two or more decrees are combined together for the effect of the same.
Okay. Uh, can you tell me for how much period the maximum period of police remand
So police remand is can only be given in the initial 15 days and not thereafter.
and then judicial remand?
Judicial remand could be given throughout, like in the initial 15 days as well, or after, according to section 167 clause 2, where 60 days is provided for 10 or less than 10 years of imprisonment in the offenses, and 90 days, and in the case of Odisha it is 120 days in cases where it is death, life imprisonment, or 10 years of punishment.
Okay. Uh, is there a provision of review in CRPC?
No, sir.
Okay. Can an accused, while mentioning or stating the accused statement, be be put under oath?
I'm sorry, sir. Can you repeat the? I didn't understand.
While examining the accused under section 313,
Okay.
can oath be administered?
No, sir.
What is the difference between proclaimed offender and proclamation?
So, proclaimed offender under section 82, proclaimed offender can be declared when he is absconding, when the accused is absconding, and there are certain offenses that are listed down, particularly, which are severe in nature, and it cannot be a minor offense where a person is declared as proclaimed offender. In those cases only, a proclaimed offender can be declared as such under 82, and there are certain setbacks also, and certain restrictions given under various provisions in CRPC, where a proclaimed offender is not allowed to uh, uh, allowed to avail certain rights. Proclamation is the declaration of the declaration where an accused is declared as proclaimed offender.
Okay. You have done your LLM, I believe.
Yes, sir.
Can you tell me the difference between a doctrinal research and non-doctrinal research?
Sir, doctrinal research is where the entire research is based on qualitative research, most importantly, like from research papers, journals, and all of those online or offline books, and all of those sources. Non-doctrinal are basically where the data is collected, basically empirical research that we call, where the data is collected, and accordingly a quantitative data is analyzed, and there are a lot of tests also, like test of hypothesis, and all of those things are done in empirical research.
Okay. Okay. Uh, yes. My last question to you is, what is the uh, difference between a Section 161 statement and a 164 statement?
So 161 statement under CRPC is taken by the police during the investigation conducted under Chapter 12, and it is not on oath, since police officers are not capable of administering oath. It can be written or in oral. It is not mandatory that the police officer converts it into written statements. However, it is recommended that it should be in writing. um, uh, and under 164, the statement is taken by the magistrate. It includes people who are acquainted with the facts and circumstances of the case, which includes victim, witness, accused, everyone. It is generally for confession. It is not taken on oath. However, it is a document which has to be in writing under Section 91 of Evidence Act, and it is in question answer form, and the magistrate is duty bound to make sure that the confession is voluntary in nature. When we come to witnesses, the statements are taken on oath, and they are also cross examined on those statements during trial.
Okay, thank you. We'll proceed to the feedback now. Sir, over to you.
Thank you, sir. Sir, I'm so
Okay,
sorry,
Jijnasa.
but in the interview was over. I'm so sorry for leaving early.
Okay. What is Jijnasa?
Yes, sir.
I put a question. What is basic structure theory,
Yes. Yes.
doctrine of basic structure?
Yes.
First thing, you should answer in one or two sentences. If
Okay.
you make your answer more lengthy, that will be more problematic for you,
Yes.
because only basic structure. Your answer will be in Keswananda Bharati case. The Honorable Supreme Court has developed this, has propounded or has declared this basic structure theory. Thereby amending a constitution, the entire structure, basic structure of the constitution can be changed. Okay, am I audible? Oh.
Net is disconnected. Let's wait a minute.
Mm. Oh, simply your
Sir, there
answer
was
should be
there was a power cut. I'm so sorry. Yes, sir.
okay. Your answer should be in the famous case or the leading case, Keswananda Bharati case. The Honorable Supreme Court has
Yes.
evolved this basic structure theory by amending the constitution as per Article 368 of the constitution. The parliament cannot amend the basic structure.
Yes.
That is there. Okay.
Okay.
Doctrine of pleasure also. Yes. Doctrine of pleasure theory, that you are correct, that as per Article 311, the every public office is held by the pleasure of the president of the government.
Yes.
That is doctrine of pleasure. Then I put a question whether getting electricity is a fundamental right.
Yes.
Your answer should be yes, because right to life.
Yes.
Right to life has been extended in many cases. You search for a case law is there also. Because
Yes.
electricity is a person will live, just stay in comfort, live in comfort with all comforts of life. That is also a
Yes.
right to life. Negligence, failure of duty to take care, that is sufficient. A
Okay.
person is expected to act as a ordinary prudent man. If he fails to act or in rashnessly, negligently, that is negligent. That negligent act. Failure of
Okay.
duty to care, and if that causes any loss or damage, then he is liable.
Okay.
Then what is crime and tort? I've told you. In case of crime, an offense is committed, and tort is a civil wrong. Other than breach of contract, breach of trust, remedy is only could damages.
Yes.
Then there are certain type of act, both crime and tort. My question was is defamation. It is also punishable under law and also tortious liability.
Yes.
More answer is not necessary. Simply try.
Okay. Yes.
Then liquidated and unliquidated damages. Liquidated damages, damages which has been determined previously by the parties. In
Yes.
case of unliquidated damages, that is not determined. After a particular act is committed, that is left to the court, that is to be determined by the court. That is as per the facts and circumstances of each case.
Yes.
That is unliquidated damages. Declaratory suit, when somebody denies somebody's legal character on any property or his status, he can bring a declaratory suit. Somebody is saying that you are not the owner of this land, he can bring a suit, declarative. But if a declaratory to simply declaratory suit is not maintainable, then further relief is required, but the plaintiff has omitted to ask for the further. That is
Yes.
maintainability. Then
Yes.
injunction, I put a question. Injunction. Injunction is an order of the court directing a person to do or not do something. That
Yes.
is injunction. Irreparable loss comes only in temporary injunction. Prima facie case, balance of convenience, not in injunction.
Yes.
That is both a preventive injunction, mandatory injunction, enforcement of the right against a person. So injunction I put no necessity. I did not go ask you what is irreparable, but you invited trouble.
Yes.
Irreparable loss means any loss which cannot be compensated in the terms of money.
Yes.
This is irreparable loss,
Yes.
not past, etc. Because why I put a problem to you? Because a poor farmer, his piece of land is giving him the food and this livelihood. If money is given in the subsequently, that will not compensate. So money compensation may be given, but that will
Yes.
cause irreparable loss. Facts and circumstances of each case will be considered separately to know
Yes.
whether there was irreparable loss or not.
Yes.
WPD, if a person has been convicted or acquitted, he cannot be tried once. This much.
Mm.
Like arrest. Arrest means taking somebody into custody, either by to the police or by to the court. When it is taken by the police, that is police custody. When it remains in the custody of the police, the court, that is judicial custody. This is, as I told you, then handcuffing. Handcuffing also there is a case law because handcuffing is done to beast, chaining. There
Mm.
is a case law. You find it. If a handcuffing is done without handcuffing can be made, but only a person has an accused has a escaping tendency. He will
Yes.
escape. Then you will be handcuffed. If handcuffing is done, that will be so much contempt will be taken because chaining is done to a beast.
Mm.
In
Yes.
civilized society, handcuffing is not permitted. Only who has a history of escaping and with the order of the court, the handcuffing can be done. Woman arrest, even the woman can be tossed only by a woman police officer.
Yes.
Woman police officer. Death a person while arresting a person. Police, if a person resists arrest, then reasonable force can be used, but will not police cannot cause death unless the accused, which you arrested, is charged with an offense of punishable with death or imprisonment.
Yes.
For that, police encounter takes place.
Yes.
A person evades police, escapes from police because he was arrested, he
Yes.
is charged for an offense punishable with death or imprisonment for life, then an encounter takes place. So that is a provision. The law
Yes.
authorizes under this.
Yes.
Magistrate without qualifying word, any magistrate, that will be section 3, it has been mentioned, of the CRPC, magistrate without any qualifying word should be construed as judicial magistrate.
Yes. Section 3.
Now,
Yes.
yes, confession. Confession is admission of guilty of committing an offense. That's all.
Yes.
Admission. Any statement, either oral and writing, we suggest an inference.
Hmm.
Statement, oral, writing, or electronic, we suggest an inference regarding fact in issue or relevant, and made by a person under the circumstances as mentioned in the Evidence Act. That is there. Then estoppel. You fail. Estoppel is a statement. If a person by his act, omission, or declaration made another person to believe something to be true, and if on that belief he has acted upon, then in a subsequent suit he cannot deny the truth of the same.
Yes.
By his act, declaration, and omission, made another person to believe something to be true. Not only that, on that belief the other person had acted upon. Then after only when a suit is filed, that is a rule of evidence. It is applicable only in civil cases,
Yes.
never criminal. That trial, inquiry, investigation you also you are also correct. Trial is a proceeding. Trial has not been defined. Trial commences after framing of charge in a warrant case or sessions case, and in summons case after substance of particular offence is explained. Trial is a proceeding after which either a judgment of acquittal or conviction is in that proceeding. That is not inquiry. All proceeding before the magistrate, other than investigation, is inquiry.
Hmm.
Investigation, all proceeding by the police to collecting evidence. That is investigation. There a provision is there also. Magistrate can direct any person to investigate. So a private person can investigate.
Yes.
Then mortgage in this concept you feel. Mortgage is a transfer of an interest as security for payment of money.
Yes.
Only an interest in a specific immovable property. Mortgage comes only in immovable property. Transfer of interest in specific immovable property as security for payment of money or money to that. Then lease is a transfer of right. Transfer of right to enjoy certain property for certain period in lieu of payment of rent or periodical payment. We should understand. License means a permission to enter somebody's land without which the entry is illegal. That is license. No right is transferred, no interest is transferred. Best example, you purchased the cinema ticket and you entered into the cinema hall. That is license. Lease is you are occupying a house on rent. That is lease. You will never forget in your life. These two examples. Then actionable claim to any debt, not movable, other than debt secured by money. Okay. Other than the claim to any debt, other than the debt secured by mortgage, then which the civil court recognizes as a right, remedy, right to give remedy, that you go through it. It's
Yes.
not movable. For adoption, what is the valid adoption? A person is that is there. Requirements of the Adoption Act are to be complied. A
Yes.
person who adopts, he is capable of taking, he is able to get adoption, he is eligible to take adoption. The three requirements. The person who is to be given an adoption, he is capable of giving adoption,
Yes.
capable of taking in adoption. These requirements. Then other things also, registration is not compulsory. If a document of adoption has been registered, then it will be presumed that all the provisions required under law for the adoption have been. That is only that can be used. Section 6 is a basing on possession. Recovery of possession, only possessory title. So
Yes.
against government, it is so be
Not.
confident and try to make short of your answer. Don't give your answer in as if you are writing it on your answer paper. You
Yes.
always try to confine your answer. Don't answer in hurriedly. Take time to answer with pause so that you will get time to answer. Have confidence and definitely you will succeed. Thank
Thank you, sir. Thank you so much.
you.
Thank you. Thank you, sir, for the detailed feedback. Jijnasa, yes, I also think your answers need to be precise. Okay, sometimes you over explain, and that may just be the problem for you, which I don't want you to do. Okay, otherwise, the conceptual clarity is there. Yes, as sir said, the some words, keywords are to be remembered, and that has to be reproduced
Yes.
because law has to be defined in the manner that has been defined in the by the legislature.
Yes.
Okay. One, two question that I asked and you could not answer is no. If lowest period of limitation, that is 10 days. Lowest period of limitation is 10 days. Highest is 30 years. And another thing that you could not answer is
So
uh,
anti-suit injunction.
anti-suit injunction. Anti-suit injunction is when you uh, when the court restrains for not prosecuting any other forum or a foreign court. That's called an anti-suit injunction. So you can't file a suit if that injunction is put. Then you can't file a suit anymore in any
Okay.
other forum. Okay. And next is doctrine of merger. That is of doctrine of merger of decree. When a decree is passed by one court and the appellate court passes another decree, I mean, either confirms it. If it confirms it, well and good. If it reverses it, then that becomes the final decree, and the original decree merges within it. That's called the doctrine of merger of decree.
Okay.
Okay. Other than that, yes, I also believe you're doing well. Just that, please keep the answers precise
Yes.
and revise all subjects once again to
Yes.
get more clarity. We'll meet for the next interview on 16th or 17th,
So,
and I'll
is there like any mark system or like average good? On what like scale am
that
right?
that that, that will be let know. That will let know in the group today.
Okay. Okay.
Okay.
So
Okay.
like sir, I'm in the like better half, or like I need a lot of
No, no,
improvement.
no, no, no. You're doing well.